3 seconds. That's roughly how long the average self-defense shooting takes from the moment the threat begins to the moment the trigger is pulled. 3 seconds. And in those 3 seconds, you make a series of decisions, fast, instinctive, terrified decisions that a prosecutor will spend the next 3 years picking apart in slow motion. They will freeze frame every choice. They will question every word you said before, during, and after. They will find a witness who heard something that sounded wrong. And they will stand in front of a jury and argue that what you called survival, the law calls murder. I've seen this happen to good people, armed, lawful, responsible people who did what they thought was right and still ended up in a courtroom fighting for their freedom. So today we are going to break down exactly what happens in those 3 seconds that determines whether you walk away or whether you get charged. Not the Hollywood version, not the range instructor version, the legal version, the one that actually matters when your case lands on a prosecutor's desk. Stay with me, because I'm going to tell you something later in this video that most gun owners never hear, and it's the part that gets people convicted. My name is Hostname, and for years I've been breaking down gun law, self-defense law, and the Second Amendment from a legal perspective, not a political one. Not to tell you what should be legal, to tell you what is legal, how it's enforced, and how to protect yourself both physically and legally. Because here's what nobody tells you at the gun store: buying the firearm is the easy part. Understanding the legal framework that governs when and how you can use it, that's what keeps you out of prison. Let's get into it. Why this matters right now. Self-defense shootings are up. Defensive gun uses happen hundreds of thousands of times per year in the United States. Some estimates put the number well over 1 million annually, depending on how you define the term. And with that increase comes something else, an increase in prosecutions of the people doing the defending. This isn't paranoia. This is pattern recognition. We've watched high-profile cases unfold in real time, cases where a person was attacked, defended themselves, and still faced criminal charges. Cases where the legal outcome had almost nothing to do with what actually happened, and everything to do with how it was framed, what was said afterward, and whether the defender understood the legal standard they were being held to. That standard has a name. You've probably heard it, but I'd bet most of you don't know exactly what it means under the law. And that gap is where good people lose everything. The standard is this: reasonableness, not heroism, not perfect decision-making, not even accuracy. Reasonableness. Would a reasonable person in your exact position, with your exact knowledge at that moment, have believed that deadly force was immediately necessary to prevent death or serious bodily harm? Every word in that sentence matters. And we're going to walk through all of it. The 3 seconds, what's actually happening legally. Let's map out those 3 seconds, because the law doesn't see a blur of panic the way you experience it. The law sees distinct moments, distinct decisions, and it judges each one. Second one, the threat assessment. The first second is when you perceive the threat. Someone raises a weapon. Someone charges at you. Someone makes a statement combined with a physical action that signals they intend to harm you. Here's the first legal test. Was the threat imminent? Imminent is not, I was scared. Imminent is not, I had a bad feeling. Imminent means the threat was immediate, happening now, not in 5 minutes, not theoretically. Courts have defined imminence narrowly in many jurisdictions. If you shoot someone who is walking toward you from 30 feet away with their hands in their pockets because you believed they had a weapon, you have a serious legal problem. The threat has to be objectively perceivable. That means a reasonable outside observer looking at the same situation would also recognize the danger. Your subjective fear is relevant, but it is not sufficient on its own. And here's the first thing most people get wrong. They think feeling threatened is the same as being threatened under the law. It is not. Second two, the force calculation. The second is when you decide to draw and fire. And this is where the concept of proportionality enters the picture. Deadly force, and a firearm is always deadly force, legally speaking, can only be used to counter a threat that is itself deadly or likely to cause serious bodily harm. You cannot shoot someone for pushing you. You cannot shoot someone for throwing a punch in most cases. You cannot shoot someone because they said something threatening without an accompanying physical action. The force has to match the threat. Now here's something people don't fully appreciate. You don't have to wait until you're bleeding to use deadly force. If a reasonable person would believe they were about to face deadly force, the law generally permits a preemptive response. But, and this is critical, the threat still has to be imminent, still has to be immediate, still has to be real and present, not imagined or anticipated. There's a phrase lawyers use in these cases: the right of self-defense is the right of the present danger. present, not past, not future. Second three, the moment after. Here's the one nobody talks about. Here's the moment that convicts people who were legally justified in firing. What do you do in the second after? Do you fire one shot or do you fire seven? Do you stop when the threat stops or do you keep going? Do you move toward the person or do you create distance? Do you call 911 immediately or do you call your buddy first? Courts and prosecutors look hard at the continuation of force after the initial threat is neutralized. The legal term is excessive force, and it doesn't matter that you were justified in firing the first shot if you were not justified in firing the fourth, fifth, and sixth. I've seen cases hinge on this exact issue. Person is attacked. Person fires. Threat goes down. Person fires again and again. And suddenly, the narrative shifts from victim defending themselves to person unloading a weapon into someone who was no longer a threat. The moment the threat ends, your legal right to use deadly force ends with it. That sounds simple. In the chaos of a real encounter, it is one of the hardest things to execute correctly. The part nobody tells you. I promised you something earlier. Here it is. The most dangerous thing you will do after a self-defense shooting is open your mouth. Not the shooting itself. Not what you did in those 3 seconds. What you say in the minutes and hours afterward. Look, I understand the instinct. You want to explain yourself. You want to tell the police you're one of the good guys. You want to cooperate. That instinct feels right. It feels honorable. And it can absolutely destroy your case. Here's why. When you are in the immediate aftermath of a violent encounter, your brain is flooded with adrenaline and cortisol. Your memory is fractured. Your perception of time is distorted. Studies on officer-involved shootings show that trained law enforcement officers routinely misremember details in the immediate aftermath. The number of shots fired, the distance, the timeline, the sequence of events. You are not in a better position than a trained officer. You are in a worse one. Every statement you make in those early moments, to police, to bystanders, to anyone, becomes evidence. And when the statement you made in shock at the scene doesn't match the statement you make 3 days later when your memory has settled, that inconsistency becomes ammunition for a prosecutor. Ladies and gentlemen of the jury, when the defendant spoke to officers at the scene, he said the attacker was 4 feet away. 3 days later, he told investigators the attacker was 10 feet away. Which story is true? And if the defendant can't keep his story straight, how do you trust anything he says? That is a real argument. That gets made in real courtrooms. The right move, and every serious self-defense attorney will tell you this, is to do 2 things immediately. Invoke your right to remain silent and request an attorney. You can acknowledge the basic facts. I was involved in a shooting. I want to cooperate fully, and I need to speak with an attorney first. That's it. That's all. And before you say that sounds guilty, let me reframe this clearly. Invoking your constitutional rights is not evidence of guilt. It is evidence of legal sophistication. And it may be the single most important thing you do after a self-defense event. What most people think the law says and what it actually says. Let me hit a few of the biggest misconceptions because these are the things people come in believing and leave shocked. My state has stand your ground. I'm protected. Stand your ground is real and it matters. But it doesn't mean what people think it means. It removes the duty to retreat before using force. It does not remove the requirement that the threat was imminent, that the force was proportional, that you were not the initial aggressor, and that you were in a place you had a legal right to be. Stand your ground is a legal defense. It is not a shield that makes every shooting automatically justified. I was on my property. Castle Doctrine covers me. Castle Doctrine is a real protection in most states, but it has limits. The threat still has to meet a legal threshold. And in many jurisdictions, Castle Doctrine applies to the dwelling, not necessarily the yard, not the car, not the sidewalk in front. The specific geography matters. He had a weapon. I was justified. Having a weapon present doesn't automatically justify deadly force in every situation. Was the weapon being actively deployed against you? Was it reachable? Was it being used in a threatening manner? The existence of a weapon is a factor. It is not automatic authorization. These aren't tricks or technicalities. These are the real legal standards. And if you don't know them now, you will learn them the hard way in a courtroom. Let me tighten this up because there's a lot here and I want it to stick. The 3 seconds that decide your legal fate break down like this. Second one is about imminence. Was the threat real, present, and immediate? Not feared, not anticipated, but actually happening? Second 2 is about proportionality. Did your response match the level of threat you faced? Did deadly force meet a deadly threat? Second 3 is about stopping. Did you stop using force the moment the threat was neutralized? or did you keep going past the legal line? And after those 3 seconds, the most critical thing you do is control your words, invoke your rights, secure an attorney, and say nothing substantive until you've had time to collect your thoughts with legal guidance. That's the framework. Imminence, proportionality, cessation, silence. Here's the truth that I want you to leave with today. The law does not punish people for defending themselves. The law punishes people for failing to understand the legal standard they're being held to when they defend themselves. You can be morally right and legally wrong at the same time. You can be the victim and still face prosecution. And the gap between those two outcomes is filled entirely with knowledge, preparation, and what you do and say in the moments after. The people who come out of these situations clean, legally, financially, personally, are not always the ones who made the perfect decision in 3 seconds. They're the ones who understood what they were walking into before they ever needed to use a firearm. They knew the standard. They knew their rights. They knew when to speak and when to go silent. That knowledge doesn't come from owning a gun. It comes from taking the legal side of self-defense as seriously as you take the tactical side. If you carry a firearm, if you keep one in your home, if you believe in your right to defend yourself and your family, then the legal framework we talked about today is not optional knowledge. This is the information that stands between you and a cell. Study it. Revisit it. Take it seriously. If you haven't already, subscribe to this channel. We break down real self-defense law, real gun rights issues, and the real legal landscape that every armed American needs to understand. Not theory, not politics. The actual law that governs your rights and your risks. And I'll leave you with this. The firearm protects your life. The law protects your freedom. You need both. Stay safe. Stay legal. We'll see you in the next one.